Hello, my name is Jordan Crenshaw, and I'm Vice President of the U.S. Chamber of Commerce's Technology Engagement Center, and welcome to our latest Tech Talk. Our Tech Talk series brings together leaders in industry and policymakers to discuss today's most pressing tech issues. Today, I'm excited to say that we're joined by FTC Commissioner Christine Wilson. Commissioner Wilson was sworn in 2018 as a commissioner at the FTC, and she previously served at the FTC under Chairman Mears as Chairman Mears' chief of staff during the Bush administration. In between periods of service at the FTC, Commissioner Wilson has practiced competition and consumer protection in both at law firms and as in-house counsel. Wilson is a graduate from Georgetown University's Law Center, and she graduated from the University of Florida. Commissioner Wilson, we're glad to have you join us today, and thank you for joining us.
It's my pleasure to be here. Thank you so much for inviting me to join you.
Well, let's get into it. So, Commissioner Wilson, the Chamber's one of its main technology priorities is getting a national data privacy law passed. And it's actually been 1,324 days since the CCPA in California was first signed into law, yet we're without a national privacy law. The FTC is the primary enforcement agency for most privacy matters throughout the country. Can you tell us why it's important that Congress pass the national data privacy law?
Absolutely. First, let me start with the preface that I speak only for myself and not for the commission or for any other commissioner. So I came to the commission wanting to dig into privacy and data security issues. And you may know I am not by nature a person who advocates for more laws and rules and regulations. I am a huge fan of free markets and market forces. But during my first few months at the commission, I had countless conversations with stakeholders of all types, businesses, consumer groups, think tanks, academics, economists, and so on. And those conversations led me to conclude that this arena is characterized by significant information asymmetries. In other words, consumers have very little understanding of how their data is collected, what kinds of data are collected, and how that data, once collected, is used and shared and monetized. And I believe that these significant information asymmetries create a market failure. If consumers don't understand what data are collected and how the data is used, they can't analyze the costs and benefits of using different products and services. So that's the consumer perspective. From a business perspective, I heard significant concern in those early conversations about predictability and certainty amid the growing patchwork of state laws and international regimes. From a business perspective, I understand that complying with myriad and potentially conflicting laws is at best costly and at worst impossible. And then to compound the problem, there are gaps in existing sectoral laws that have created inconsistent privacy protections. And those gaps continue to widen. The healthcare arena is a great example. It's one I was using before the pandemic. Information collected in traditional medical settings is protected by HIPAA, but information collected through websites and apps and wearables is not. And then the pandemic hit, and it became evident that COVID-19 only exacerbated this issue. And that's not the only area where we have emerging gaps in existing legislation. And then I think it's important to note that the concern extends beyond consumer privacy. Certain uses of consumer data also have serious implications for civil liberties, including our protections under the First and Fourth Amendment. And these concerns also intensified during the pandemic. Now, let me be clear. I am not saying that the FTC should be involved in civil liberties issues, and I am not saying that privacy legislation should address these issues head on. But the fact is, the commercial and the constitutional issues are inextricably intertwined, given the prevailing legal tests and the purchase of commercial data by the government. And this is one reason that I support the Fourth Amendment is not for sale act. So for all of those reasons, we need federal privacy legislation, and federal privacy legislation is long overdue.
Commissioner, I couldn't agree more about the need for a national privacy law. You mentioned some of your partnerships in reaching out, especially with regard to academics and continuing with privacy. You've recently partnered with Duke University, which has been doing some research on potential privacy legislation. What has that work found, and what are your thoughts about how this impacts the privacy debate?
So this has been a great project. In fact, it was one of my professional highlights in 2021. So early in 2021, I appeared on a panel with Professor Hoffman, and afterwards we got to talking, and we realized that both of us had been urging Congress for a very long time to pass federal privacy legislation, but in fact there were some very significant gating issues that prevented Congress from getting this across the finish line. Instead of continuing to harangue Congress, we figured perhaps we should take some time to think about constructive solutions to overcome the hurdles that they have hit. And so obviously those two issues are preemption and private rights of action. And so we dug in. Now, our goal was to identify the different approaches that Congress has used with respect to these issues in other legislation, including but not limited to privacy laws. Cam Carey at Brookings also floated some draft legislation the year before that took this approach. So in digging in on this topic, our student researchers analyzed preemption and private right of action provisions in many US laws and in the GDPR. And they also reviewed case law review articles, and a significant body of scholarship on preemption and private rights of action. We also talked to many academics and people at think tanks, and then held a short conference that enabled all of those different people to share their views on these issues. Duke has placed the results of this research on a Duke-hosted website, and it's public. It's available to everyone. And we do hope that this compilation will demonstrate that preemption and private rights of action can be addressed constructively in the context of federal privacy legislation. So that's sort of the purpose and the context for the project. Let me tell you at a very high level what we found. On preemption, we found that federal statutes that preempt an entire field of law are actually rare. And on the flip side, we found that even scholars who don't support preemption acknowledge that there are circumstances under which federal preemption, federal consolidation, has benefits. And the point is that preemption doesn't need to be viewed through an all or nothing lens. And in fact, that isn't the way Congress has approached it in the past. There are many points along the spectrum between all and nothing that Congress could choose to land. For private rights of action, we sought to analyze the goals of those who advocate for a private right of action. One frequently stated rationale points to under-resourced government agencies like the FTC and concludes that private rights of action are necessary to provide incremental deterrence for businesses and remedies for consumers, and they view private rights of action as a force multiplier. Now, a strong privacy law that includes sufficient funding for the FTC could obviate this need and address those concerns. From a personal perspective, I've long been wary of private rights of action. I've had enough experience representing clients to understand, and I know that this audience understands, that abusive class actions increase costs for businesses. And in fact, they provide little in the way of deterrence or changed business practices, or perhaps most importantly, redress for consumers. Even if we were inclined to give class actions the benefit of the doubt, the research conducted during this project leads me to conclude that we need to broaden the conversation. Instead of arguing about whether we should have private rights of action or no private rights of action, I think it would be more constructive to focus on establishing a constructive remedial framework, considering the policy goals of the regulatory regime and how best to accomplish those goals, and how best to create appropriate levels of deterrence. It was a fascinating topic, and eventually it will lead people who are thinking carefully about this to realize that we need a multi-layered approach. It's not a one-size-fits-all. Chris Hufnagel and others wrote a really great article on the topic that I commend to you. And in fact, I also commend to you the Duke website and the 2-hour seminar that we put together in the fall. It was a really complex and nuanced discussion among people who think carefully about these issues. And I think it's a great resource, not just for Congress, but for policymakers and academics and others thinking carefully about these issues. So the bottom line is that this project demonstrated conclusively to me there isn't one right way to handle private rights of action and preemption. And so I encourage Congress to consider the many possible permutations and to choose one and to get legislation enacted.
No, I think you raised excellent points about some of the concerns about abusive class action suits and privacy legislation and privacy enforcement. Talking a little bit more about the enforcement side, a lot has been discussed about enforcement at the FTC regarding things like Section 13B or a new privacy agency or bureau within the agency. Although Congress hasn't passed a national privacy law, some have called for the creation of a new privacy bureau and changing straight to penalty enforcement absent that new privacy law. What are your thoughts on the provisions and things like the Buildback Better Act regarding straight to penalty authority and that new proposed privacy bureau?
Yeah, so let me start with some context. I am really glad that legislation now is talking about putting this issue in the hands of the Federal Trade Commission. There have been proposals to create a new agency, and I just want to confirm that the FTC is the right agency to handle privacy. As many of your viewers know, we have broad and deep experience in this area. The Commission has brought at least 150 privacy and/or data security cases. We've held more than 70 workshops and issued more than 50 reports and studies during the last 20 years. And absent privacy legislation, the FTC has developed a common law of privacy through our very limited Section 5 jurisdiction. This actually began with a vengeance under Chairman Muris, whom I served as chief of staff, with the Microsoft and the Lilly cases. And those were seminal cases in this area that began to build out using Section 5, essentially what folks have called a common law of privacy. So the FTC is doing everything that it can within the limits of its jurisdiction to protect consumers in this area. But obviously, we can't completely address the issues in today's market given our existing jurisdiction. And I continue to say we need federal privacy legislation. But with that context in place, the proposals in Build Back Better to create a new privacy bureau and to provide straight penalty authority for the agency raise concerns for me. I only want a separate privacy bureau and a significant increase in funds if the additional resources are coupled with the guardrails of new privacy legislation. The current leadership of the FTC has embarked on a sweeping campaign to replace the free market system with its own rules governing how companies should operate. They want to replace a consumer-oriented focus with subjective goals that are ripe for political manipulation. And because FTC authority is so broad, current leadership can touch almost every aspect of our economy. So frankly, I am dubious that current FTC leadership would wisely exercise sweeping civil penalty authority, and who knows what future administrations will bring. So as I've said before, I believe injunctive relief alone does have a deterrent effect and can effectuate changes in the market. And that is the approach that we should continue to use for Section 5. I don't think we need new civil penalty authority on a broad Section 5 basis. And I want a new privacy bureau to be grounded within the guardrails of new federal privacy legislation. Let me just clarify. In the past, I've supported civil penalties within the context of privacy or data security legislation for first-time offenses. And I continue to support that kind of proposal. But there, the civil penalties would be limited to certain types of practices and incorporated into legislation that clearly defines agency boundaries and jurisdiction. But Build Back Better goes too far in granting first-time civil penalty authority for all Section 5 offenses. Also, and I know this is a topic of conversation at the chamber, I would rather see a fix to 13B than civil penalty authority for the FTC. And here's why. One reason why. Unlike the CFPB and other agencies, the FTC civil penalties must go to the Treasury, and we can't use those funds to provide redress to consumers. And the FTC has always prioritized consumer redress and settlements with the goal of making consumers whole. So for those reasons, I remain a bit concerned about the legislation that we're seeing on the Hill.
No, I think you raise a very excellent point about the need for guardrails in a privacy law if you're going to expand, the number of staff at FTC and also expand civil penalty authority in that space. I would say that, FTC definitely makes sense, I think, in terms of still keeping its primary role as the lead privacy enforcement agency. Excellent points and really interesting to hear your thoughts there. Switching gears, just last month, we at the Chamber announced the launch of our new AI Commission on Competitiveness, Inclusion, and Innovation to help define AI and propose some bipartisan policy suggestions. Just recently, the FTC's regulatory agenda mentioned a rulemaking and automated decision making, and not to speculate in any inside baseball, but generally, do you think the FTC is ready for rules on artificial intelligence, and what are some of the benefits that you see AI providing?
So, as I said at the outset, and as I have said many times publicly, I approach my job and the role of government with a deregulatory mindset. Rulemaking is problematic because its costs frequently outweigh its benefits. And we have relevant historical experience here. Let's learn from it. The now defunct regulatory regimes for airlines and railroads stifled innovation, increased costs, raised prices, limited choice, and decreased output. Even Chair Khan admitted in a 2012 article that, quote, any regulatory regime can degenerate and wind up stifling competition, and often rules harm the very parties they are intended to benefit. So my general approach to rulemaking is skepticism. And given this context, you won't be surprised to hear me say AI rules at this point in time are a really bad idea. So even setting aside my personal aversion to rulemaking, I believe the FTC is a long way from making sensible rules in this area. This is a nascent market that requires study, and it requires room for growth because we do not want to chill innovation and competition. And we're still exploring the potential of AI. So we don't want to get in the way of its robust development. We know AI can shrink the time and cost of executing complex tasks. We know AI can help industries rethink how to integrate information and analyze data and improve decision-making. That said, I also recognize that AI carries with it potential pitfalls. Take, for example, facial recognition technology. We've seen facial recognition technology used to surveil protesters. Does this infringe on First Amendment rights? We've seen facial recognition technology deployed without warrants against American citizens. Does this infringe on Fourth Amendment rights? These and other issues led leading technology companies to announce a moratorium on the development or sale of this technology until there's a federal standard. And the specters of mass surveillance and racial profiling and abuses of basic human rights and freedoms outweighed for these businesses the benefits for many companies that elected to suspend research and development in this space. So the bottom line is that AI does hold the potential for great benefits, but there are also risks. It's a complex, nascent area. We don't want to chill innovation and competition. I think we need to keep a watchful eye. But for now, the FTC is not ready to engage in AI rulemaking. That is not to say AI will have zero oversight. The flexibility of Section 5 creates opportunities for the FTC to police consumer harms in emerging areas of tech. During the last 20 years, we have carefully and thoughtfully intervened in the marketplace, bringing privacy and data security cases using that Section 5 authority. And as AI develops, we will be able to consider unfair or deceptive active practices that are associated with AI. But for now, let's stay away from any rules in this area.
I think that's a very good point, Commissioner. And, we stand ready to work with you as we help develop some bipartisan solutions in this space. But I think the rush to regulation is something that we don't want to see. And getting policy right matters. Switching gears a little bit, going a little bit further out, more broadly, what are some of the major issues in tech that concern you right now?
So that's obviously a broad question, and I'm gonna go for it. So obviously we've talked about the consumer protection front, and I'm focused on the need for federal privacy legislation there. On the antitrust front, I am concerned by attempts to use big tech as this Trojan horse to facilitate an overhaul of antitrust writ large. Note that the House Judiciary Committee purported to be focused on big tech, but its report actually contained proposals that extend into many other industries and areas. And while the neo-Brandeisians initially whipped up controversy by focusing on big tech, the president's executive order on competition similarly goes far beyond that sector. So let's discuss some initiatives that are ostensibly focused on big tech, but have a broader impact. First, I reject the assertion that the antitrust laws are outdated and incapable of dealing with new and emerging technologies. The Antitrust Modernization Commission rejected this assertion, and so did the Microsoft Court. And we currently have several ongoing lawsuits pertaining to tech companies. You're familiar with the Facebook and the Google suits, but the FTC also launched, not quite as high profile, but just as important, a monopolization case against SureScripts. That's a platform for e-prescribing. Perhaps we should let these cases run their course before we overhaul the system. Now, the antitrust laws are broad and they're premised on economic analysis, which continues to evolve. And to be clear, antitrust is not meant to be static. The Supreme Court made this clear in Kimball v. Marvel. So I support analysis and retrospectives, and I'm not saying that we've always gotten it right. But just because we're analyzing dynamic technology markets doesn't mean the economic principles we rely on should be discarded. Second, I call foul on critics of modern antitrust law who point to the failed attempts to regulate competition in the airline and railroad industries as stellar models for regulating tech. As I mentioned previously, those massive regulatory regimes were repealed on a bipartisan basis because they hindered innovation, raised prices, lowered quality, and harmed their intended beneficiaries. I'm also gravely concerned by draft legislation that seeks to ban conduct that frequently creates benefits for consumers and draft legislation that threatens to chill innovation. Some proposals don't even target companies with market power, but instead focus on size. Others disregard actual anti-competitive effects, and they try to adopt bright line rules, which is a step backwards from our modern and effects-based and economically grounded analysis. Third, these proposals ignore the consumer welfare standard in favor of a competitor-first approach, which favors inefficient rivals instead of consumers. This is a terrible idea. And fourth, some of the proposals shift the burden of proof for conduct that's likely to be pro-competitive. This shifting defies our general understanding of due process, but it also comes with massive civil penalties that are going to encourage baseless lawsuits. Going back to the point about the consumer welfare standard, I reject the assertion that the consumer welfare standard only analyzes price and fails to measure other harms to competition, like innovation. The 2010 horizontal merger guidelines may not be around for much longer, but they currently say market power can be manifested in non-price terms, including reduced quality and innovation. Our cases bear this out, and any judge can apply this standard even in the tech industry. So I oppose attempts to replace the consumer welfare standard with a standard that injects non-competition considerations into antitrust analysis. The consumer welfare standard is administrable, predictable, and credible. Inserting non-competition considerations is going to allow for arbitrary enforcement that reflects political motivations, not reasoned and objective assessment of benefits and harms to consumers. And I think we'll get into this in a minute, I'm skeptical of all the changes enforcers are making at the agency level.
So I think that segues quite nicely, and I don't think we would have had a proper interview if we didn't talk a little bit about some of those changes that the FTC has come under fire for, and actually learning new terms this year like zombie votes and some of the transparency allegations that have been raised. Are there areas where you believe the FTC should modernize or improve process? Does Congress also have a role to play here?
Great questions. And for the record, I will give credit to Commissioner Phillips for the phrase zombie votes. That is That's his phrase, his brainchild, and it has certainly gone viral. So that phrase and others like Rulapalooza emerged in the first few months under Chair Khan. Those first few months of her leadership represented a full frontal assault on the FTC's longstanding tradition of bipartisanship. Many significant policy initiatives were rammed through on a 3-2 basis and with barely any notice to Commissioner Phillips and me. Rescission of the bipartisan Section 5 policy statement and rescission of the vertical merger guidelines fall in this category. On other fronts, power was consolidated in the office of the chair, undermining the traditional role that the commission has played. Now, the chair controls the MAGMOS rulemaking process and is free to stack the deck in accordance with her agenda. And while formal investigations used to require a majority vote, they can now be launched by one commissioner alone. Each commissioner brings his or her unique perspective and experiences to this job. I learn from each of my colleagues, including former Commissioner Chopra and Commissioner Slaughter. And this diversity of perspectives and policy preferences and experience enables the body to consider issues in a far more comprehensive and nuanced way than any one of us could or would on his or her own. But when the chair employs a go-it-alone approach, the value of the commission is undermined. You mentioned transparency. Despite the chair's emphasis on transparency, this is an agency that is communicating less, not more, with the public. I call it the transparency paradox. So in the name of transparency, the chair began scheduling open commission meetings. But to protect the deliberative process privilege, we are not permitted to engage in discussions with each other at these open commission meetings. Instead, we read statements that would have been published on the website anyway. Another example, our rules of practice were changed to limit, not expand, opportunities for input by public and staff. Ongoing rulemakings have been short-circuited by definitive policy statements, which renders public input moot. The health breach policy statement is just one example of that. And our experienced staff has been muzzled. You will not see FTCers on panels or at conferences. And to me, this is perplexing. Getting the word out about our enforcement intentions and our policy preferences helps industry comply with the law. Silencing staff leaves a void and creates further uncertainty. So I have been really disappointed by the steps taken to limit what used to be a robust dialogue, both at the commission level and with staff. We may not always agree with each other or with staff, but our analysis is deeper and richer when we consider all arguments. And make no mistake, just as I learn from my fellow commissioners, I learn from our staff on a daily basis. Some of the most talented lawyers I know work at the FTC. Procedural safeguards ensure full participation and better outcomes. Crushing internal dialogue and thorough analysis diminishes the quality of our decision-making. For example, the statement that the majority issued when they rescinded the vertical merger guidelines contained basic flaws in economic analysis. And leading commentators, when they read that, wrote a blog post saying, the majority appears not to have consulted with their own economists in the Bureau of Economics. So it has been disappointing to see the abandonment of longstanding bipartisan traditions at the FTC. Process matters, and the ends do not justify the means. I saw on a quote, there was a quote in an article recently saying that my concerns really focus on the style of our new chair. Due process is not a trend. It's not a fad. It's not a type of leadership. Due process is a founding principle of this country. So as for whether there's a role for Congress to play, I think leaders on both sides of the aisle should think long and hard before increasing our funding or our authority if the commission can't demonstrate an ability to work in a bipartisan way. But to provide another segue, to be fair, the 2-2 stalemate at the agency has required the chair to engage in more consultation with other commissioners. I am confident that because of this consultation, the outcomes and the work product have been improved during this period, and I hope that this muscle memory is retained once Alvaro Bedoya is confirmed.
Commissioner Wilson, I think you hit it right on the head. Due process matters. and making sure that we get good policy is also something you've been a leader of as well. And so I appreciate you providing your insights today and joining us. I want to thank everyone for joining us today for this Tech Talk as well. But thank you, Commissioner Wilson. We really appreciate it.
My pleasure. Thank you so much for having me, Jordan.
Thank you. And for those of you who want to learn more about what the Chamber is doing and the Chamber Technology Engagement Center is up to, I ask you to visit AmericanInnovators.com. And we look forward to seeing you at our next Tech Talk. Thanks again.